Every tear for his remorse. Oceans you fill for yourself alone. Fluorescence in that now dethroned. So pity your river, not a drop for him. Your high ground's a shadowy wasteland. Samson night back with your selfish walls. No room for the tears, only you.
Hey guys, it's Mo. It is the 1st of October, and we are looking at the state's motion to strike the defendant's motion to suppress the statements at the jail. So this would be her interrogation. But also the body cam footage that was collected from the officers that were first on the scene. Again, there is sort of this startling thing that in Sarah's motion to strike this, they didn't even cite the state law or the state case law or even federal case law of Miranda versus Arizona, which you think they would if they were wanting to strike down, something for a Miranda violation. But the state is not having any of this. And from what I've heard, the state goes a bit ham. So, welcome to everyone, and we will get into this. The state's motion to strike the defendant's motion to suppress statements at OCSO, and the state's response to the defendant's motion to suppress statements at OCSO. Now, this is all hinging on Sarah's lawyer claiming that Sarah was not read the final phrase on that little Miranda card that basically, and I'm paraphrasing or not getting it correctly, or I'm not going for word accuracy, but it basically says, keeping all these minds or rights in mind, are you willing to talk? Well, Sarah does not ever say, wait a minute, what were those rights again? Or I have a question. Or, I think I should get one of those things, those people that represent people in these kind of cases, a lawyer. No, she continued to talk. So Sarah Boone, whether, all of the words were said correctly, I believe Sarah Boone understood that she did have a right to counsel. She could, retain that right at any time. She could exercise her right to say nothing. So this whole cockamamie BS of, well, they didn't say the last line. Well, Sarah didn't exercise her right to remain silent, though I do not know if she has the ability to remain quiet. So here we go. Comes now the state of Florida by and through the undersigned assistant state attorney. The state states and alleges as follows. 1. The defendant's motion is legally insufficient. The defendant recites allegations of facts, but not why any particular fact or facts is an issue. Again, I have not been very impressed by Sarah's lawyer. I feel that he compliments her, but in the worst way. And this is what I think about that. He has the same whiny, entitled, bratty sort of attitude. You could see that in the past hearing, where every time he got up, he continued to complain about not getting a continuance. So he really doesn't strike that more professional note. He always has like a sigh or an attitude or just a very unpleasant tone in his voice when he is told no. And I do not think that this is the lawyer that you should go with if you are Sarah Boone and you are wanting to evoke sympathetic feelings. But they are, in fact, true. This is, in fact, true. The motion to suppress the interrogation had no facts of why it was wrong, what they wanted as a relief or anything like that. And not being a lawyer, I know that you're supposed to have at least some case law. I mean, usually I skip over it when I'm reading it because how many subsections can one thing have? I feel like the Little Mermaid. How many subsections can one statute hold? I mean, just a gajillion. I think lawyers love subsections, that's all I'm saying. But it doesn't have any of that in there. This is more like a report of, "Mommy, they're touching me, but they're not touching me." Quote, "The reasons for suppression," end quote, "as required by Florida Rule of Criminal Procedure 3.190, subsection 8, subsection 2, I'm telling you, lawyers love their subsections, is a boilerplate assertion that it violated U.S. Constitution and the Florida Constitution. This is no different than stating, quote, "A search was performed illegally and improperly and unlawfully," State versus Christmas, Florida 4th District, 2014, but also see Ross versus State, Florida 2nd District, 1999. Motion to suppress that cited 11 authoritative cases was legally sufficient. I mean, that's how I've been making up my description, so maybe that's that's what it is. The defendant has not even cited a single case that authorizes the court to grant her the relief she is requesting. Boom Her says, as a pro se litigation, I included tons of current and past rulings in my footnotes. References took up the entire page. Absolutely correct. And what a good, I mean, that's a lot of research. You have my awe for trying to even do that by yourself, because it is too complicated. There are, legal forms and sort of ways of writing, and I think Bite Me would constitute most of my filings, so I'm not even sure that's a, original one. But you need to have all this sort of base knowledge that you can pull up, or how to put things in documents. So I would assume that her lawyer would know how to do that, but apparently not. The state is left in the dark about what specific issue or issues the defendant is claiming and what legal authority there might be for the court to grant the relief she requests. State versus Butterfield in the Florida 4th District, 1973, the court should strike the motion as legally insufficient. 2, the state objects to any additional claims being raised at the hearing that were not specifically pled in the defendant's motion, State versus Christmas. So I do like putting this in here because I think that Owens is the type of lawyer that is going to come up and say, "No, what we meant was this, this, and this, and this," and try to move the goalpost. He should know that what you put in documentation is, paramount, and then you argue off of that. But the fact that he didn't put any sort of, citations in there, I believe this is perfectly fair for the state to ask for. 3, in paragraphs 5 and 6 of her motion, she alleged she was detained for 14 hours, and during this time, she provided a statement to law enforcement. She does not challenge the admissibility of this statement. Chavez versus State, Florida 2002, 54 hours of detention does not make a statement involuntary. Again, she voluntarily opened her mouth hole and words flew out of it. It's not like they were, taking out anything. I mean, the only thing that was slightly scary about that was the shininess of this, the male detective, his shirt, but she in no way felt scared to talk. In fact, she wanted to set the record straight. She wanted to talk about a coat hanger or a curtain rod that had nothing to do with it. Jorge dancing with the dog, bringing up her cell phone. I mean, again, she was never, exhibiting fear responses that I saw. And I'm not a bodyologist, but I'm just saying, she didn't look uncomfortable in the least. In fact, she was so arrogant and assertive that when, the police officers asked what happened, she said, "Tell me and we'll both know," with an attitude and the little chicken head bob thing. So miss me with this noise, Miss Boone. 4. Paragraphs 7 and 8 of the defendant's motion allege that law enforcement asked the defendant to turn over her phone and that she was provided the means to she provided the means to unlock it to law enforcement. Bell versus State is informative on this issue if it is the defendant's position that this somehow rendered her statement the following day involuntary. Again, I believe she wanted to give over her phone. She thought it would exonerate her. So she happily signed that waiver that said, "Hey, can we look at your phone?" And she was like, "Oh, heck yeah. You'll see all of, George's badness and my, abundant goodness as an honor roll student." 5. Bell makes it clear that the police having seized evidence from the suspect and the suspect knowing they have seized evidence from her only goes toward the analysis as to whether a future interrogation is quote unquote custodial, not whether a future statement is quote unquote involuntary. Because Miranda warnings were provided at the beginning of the interview the following day, this is not a relevant factor for the court to consider. Well, I mean, I don't know, but I would have enjoyed seeing a motion of just grounds. Again, this feels to me like this is a very Sarah Boone-led defense, and, if this is what she's been wanting for the entire time and she finally found a lawyer who doesn't care about making these arguments that make him look ridiculous, then good for her, but I don't know that, again, the comedic duo of both of them are going to push this, it was an accidental self-defense suitcasing. I don't know how we're gonna figure that one out, but that is a hearing I'm waiting to see. Oh, 6. Bell is also informative on the distinction between a Miranda violation and an involuntary statement, which will be discussed below. 7. Paragraphs 9 through 11 of the defendant's motion imply that law enforcement was being deceptive in their manner of summoning Sarah for her interview, uh, or for an interview she did not know was going to occur. Pursuant to Bell, this goes to one of the Ramirez factors in deciding whether Miranda warnings are required, not whether a statement is involuntary. Yeah, I believe that this is absolutely, I don't know. To be honest with you, Owens is a pill, and I have a hard time always paying attention to him without thinking, what in the clown music is going on through your head? But I do believe that this is a very defendant-led defense. I think that the other lawyers were not going to deal with this. They didn't want to cotton to Sarah's way of thinking that no, she was not, unlawfully interrogated and she's not been unlawfully, you know, incarcerated against her will because America hates her. It's just, it is what it is. I mean, if this is the case, if they told her that she was coming in just for an interview, how do cops then, arrest people where they get them for those, like fraud things? They tell them, "Hey, you want a boat? Come down to such and such a place, and you'll get the boat." And it's all people with outstanding warrants. I mean, at some point, what is going on here? What are we arguing about? Number 8. This is different from deception that would lead to an involuntary statement. The defendant received no promises of hope, leniency, or misrepresentations about the law. Johnson versus State, Florida's 4th District, 2019. Both the United States Supreme Court and the Florida Supreme Court have held that deception alone does not negate voluntariness. So again, this is why police officers are allowed to, tell you like, "Oh, we've got all the evidence against you." And, "Oh, we have your DNA, your fingerprints, this, that, and the other." This is why you need one of those lawful law people to, come in and say, hey, is there any reason that your fingerprints would be on this suitcase, Sarah? And then they can kind of sort this thing out for you. Let's see. Which versus State, Florida 2008, this includes misrepresenting a co-defendant's statement, false suggestions that law enforcement can arrange a satellite system to pull a defendant or put a defendant at a scene, exaggerating the amount of DNA evidence against a suspect, informing a suspect that law enforcement was investigating a missing person case rather than a homicide, writing, quote, DNA evidence on a whiteboard in an interview room prior to any DNA analysis being performed, and false representations of physical evidence that did not exist. So, again, these are things that, again, we could do that. Okay, Lisa Pearson, I knew I had seen a story about that. But yes, I knew that that had happened. So, by Sarah Boone's reasoning, then all, people being called in, just to talk with the police should all go free. 9, luring the defendant to the sheriff's office under the guise of returning her phone to her, if that is what in fact happened, does not make the statement involuntary. It only goes towards whether Miranda should have been read, and it was. So, yes, there are different things, and her being told that she could get her phone back was just a hook because, she was having, if you remember in the interrogation, she was like, "Is today February? Today's Monday to Thursday." I mean, she could barely place what time it was, even though she was so distraught about George, she never cried, and she wanted to get his engagement ring back. That just means, hey, should Miranda be, read? And it was. Number 10, paragraphs 12 and 13 only go toward the first Ramirez factor as to whether Miranda should have been read to the defendant. She was led upstairs to one of the interview rooms in the sheriff's office by Detective Lowen, where an interrogation ensued after Miranda was read to the defendant. 11. Nor is there quote unquote coercion, although the defendant has not specifically made that claim or cited authority. Martin versus State, Florida 2012, allegations that law enforcement, 1, threatened the suspect with the death penalty, 2, deluded the suspect as to what he could expect for himself from a jury if he confessed, 3, deceived the suspect to the amount of time he had to cooperate with law enforcement, 4, promised their favorable testimony and use of their influence during his trial if he cooperated, 5, promised to arrange a visit for him with his girlfriend if he cooperated, and 6, exploited his religious beliefs by relying on a version of the Christian burial interrogation technique. Did not render the statement involuntary, though it presented, quote, the very outer limit to what tactics law enforcement may employ when performing custodial interrogation. So all of these things that are considerably shady, and I would call, maybe very close to treading that line, the state did agree as well. None of those things happened with Sarah. I mean, the closest you could come to them saying that they were going to, assist her was saying, "I don't know how to tell you not to be charged with second-degree murder." I mean, that was fairly, you know, mild to me. 12, though the defendant never states that part of the reason she believes her statement should be suppressed was the quote unquote minimization of her Miranda warnings, nor cites any case law on the subject, the state infers that she believes this an issue due to what she has underlined in paragraph 15 of her motion. 13, there are several cases addressing the issue of quote unquote minimizing uh, the importance of the Miranda warnings. Ross versus State, Florida, 2010. Thomas versus State, Florida's 1st District, 2022. Rios versus State, Florida 5th District, 2019. Wright versus State, Florida 15th, 2014. Chafin versus State, Florida 4th District, 2013. So it's not as though there is not case law laboriously looking at some of these issues and really seeing, okay, when and where do these things cross the line? And the very interesting thing is that each one of these states is going to have, or these cases is going to have a different interpretation or a different reason that they believe that they might have been out of line. So it's not as though her attorney, again, did not have access to this, didn't know that there were several cases. I'm sure there's like a smart loyal lawyer like Google thing where you can put like cases involving the Miranda rights in Florida, and then click and it'll give you applicable cases. I don't know, but I'm guessing that would be something he'd have access to. 14. Saying, quote, "This is something I have to do," end quote, is not minimizing according to Wright, which is analogous to Detective Copsell saying, quote, "I'm going to read you your rights again because we have to talk about that. We just have to do it," end quote. I mean, it's absolutely something that I don't think is discriminatory or anything. They were read in normal cadence, like in Chafin. There was no delay in reading them. The defendant is not a juvenile, and there is no claim that she is below average intelligence. Oh, someone get some aloe, because Sarah Boone's going to be feeling a burn right now. Someone just disrespected her honor roll from, being a senior in high school 27 years ago. Sarah is losing her shit when she reads this, and I am loving it because they just called her intellectually subnormal, allegedly. Well, no, she's Copus Mentis and everything, so she should have seen this trick coming. She should have been like, I am keeping my eyes on. Don't you cops do anything shady. I know all the case law in Florida about Miranda. She had been read her Miranda warnings just a day before and acknowledged this. It is the defendant who says, quote, "normal protocol." 15. These statements by law enforcement do not render her waiver of her Miranda rights involuntary or her statement involuntary under the totality of circumstances analysis. 16. In the balance of paragraph 15 of her motion, the defendant outlines Miranda warnings as they were given to her by Detective Copsell. 17. Paragraphs 17 through 21 outline what she believes the sheriff's office Miranda card says and how it differs from what she was told by Detective Copsell. Again, from what I saw of the, exemplar, little Miranda cheat sheet card that she got, all that wasn't said was, yeah, reindeer. It's almost like 8 other attorneys said, no, this is dumb. This is dumb, and the law doesn't mean what you think it means. And then this 9th attorney is like, no, this makes a great point. You guys, you and me are best friends. Sir, I'm going to tell you, Sarah will turn on her friends and lock them in a suitcase. So I'd be careful, because I don't know that I want to be friends with Sarah. Now let's see. 18. Interestingly, the defendant believes that this creates some sort of legal impediment to the admissibility of her 2-hour statement. That day, it is not backed up by a single citation to any legal authority within or without the state of Florida's court system. 19. Instead, she makes a boilerplate assertion in paragraph 22 that her statement was quote unquote involuntary and her waiver of her Miranda rights was involuntary. 20. Fortunately for the state of Florida, there is case law on this issue. Oh, we are dropping the lawyer mic. They were like, bam. They were not, the state has been waiting to write a snarky motion back to this guy. And they're like, we're going to drop some knowledge on you. Yeah, so Owens needs a psychological exam. I believe he's trying for a mistrial, so he can tell TV circuit for a year, I did my best. He wants to blurt out in front of the jury he essayed her. Yeah, look, Sarah Boone has so many issues when it comes to the battered spouse defense. I can't imagine. I can't imagine a less sympathetic character that is going to really give you any sort of optics of a battered, subdued, fearful woman. She comes across strident, unrepentant, and absolutely beyond all rational thought, deeply rooted in her innocence and lack of responsibility. Again, had Sarah done, possibly what everyone else thought she should have done, admitted responsibility and taken a plea deal, this would not still be an issue. But she wants to fight this, and she has this delusional thought that unintentional means not guilty, which has never been anything part of the law. But that does really stick in my craw. The fact that she has never once to in anything that I've seen, she's never in her, gajillion and 23 letters written by a big pen, a little penlet, ever said, I live with the terror that and horror and pain that I've caused George's family and him in his final moments. Because she doesn't. And it's just gross. And it seemed like, again, boom her, especially when she has multiple charges against her for DV. Yeah. To the casual outside observer, she and Jorge seemed to be two people that got very violent with each other when they drank. And that seemed to be the only thing they had in common, that they drank together. It seems like she kind of got lucky with her husband, Brian, and when she would go off the deep end and claw and attack him, he would never lay hands on her. But she didn't find that in George. She found someone who was going to basically engage in mutual combat with her. She seems combative. She seemed arrogant. She seems shrill and strident. And none of these things are going to go forward for you to, even halfway pull off the personality transplant you would need to wear the cloak of victimhood. She is the worst imposter. She's not a great actress. And I think the state, if she does testify, or even if she doesn't, let's be honest, are we assuming that Sarah Boone can sit in the defendant's area and have someone, speaking the basic truth about her? And that's why I would have Brian be my first witness if I were the state, her ex-husband, and basically go through all of the abuse he suffered at her hands and the fact that she was unfaithful to him. Because if you noticed the timeline in Sarah's body cam video, Brian's like, oh, they've been dating for 3 years and we just got divorced a year and a half ago. Again, if she were smart, she would have taken a plea deal a long time ago, but she's not. So she's going to drag George's family and everyone else around her into this, just like she was going to drag her brother and her mother into letting her have bond and be, an absolute complete chaos agent of chaos out there, screwing their lives over with no thought of how this could, hurt her brother's, special clearance and anything like that. Just nothing. No thought for anyone but herself. Okay, let's see here. 21. There is no specific way that the Miranda warnings must be given. And with all due respect to the Orange County Sheriff's Office, they certainly do not have the authority to tell this court what is sufficient Miranda warnings are. Reigertink versus State, Florida 2011, Kramer versus State, Florida 2020, Morris versus State, Florida 2017, and State versus Owens 2010. 22. While the 4 required warnings have become embedded in police practice, the specific words used varies, and the Supreme Court, quote, has not dictated the words in which the essential information must be conveyed, end quote. Morris versus State. Quote, there is no talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. Again, if we wanted to take this up, if this is a hill that, Sarah wants to die on, then go to the Supreme Court and have them dictate, and like a rosary of what we are supposed to say. As a recovering Catholic, I can tell you that, we can do 20 Our Fathers, a couple Hail Marys, but there is a specific you know, wording and way you have to do things. If that is what you are wanting from the state or from the Supreme Court, then you need to fight for that. But at this point, they have already said there are no, ways that you absolutely have to say this. We will leave it up to your discretion. Generally, I know there's the little card and there's that paperwork that, the defendant or whoever's being interrogated, is asked, hey, can you write and can you initial things here? Can you read and write English? What is your level of education? Things like that, that might dictate that things need to be said in a simpler or plainer, form, and really make sure that the defendant understands what their rights are, which is why you need elasticity and not this sort of talismanic incantation, which I think I'm going to steal from now on because it would be a great name for like a punk Wiccan band. Just saying. Let's see. Reigertink at 890 citations omitted. Quote, rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda, end quote. The crucial test for determining whether police gave a proper warning is whether the words used in the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all his rights. Again, this is why it has to be elastic. You can't have the same Miranda warnings conversations with Sarah Boone and then, let's say, a 10-year-old who's done something wrong. You can't, because they're not going to understand the same vocabulary, the same verbiage, and what these things actually mean. So you have to be able to kind of customize this within the limitations of who you're talking to. 23, Detective Kopsel specifically instructed the defendant on each of her 4 Miranda rights. 1, the right to remain silent. She just doesn't have the ability. 2, that anything said can be used against her. Pretty much that entire interrogation will be used against her forever. 3, she had a right to an attorney before and during questioning. And 4, a lawyer could be appointed if she could not afford one. The detective then asked the defendant if she understood these rights, and the defendant said she did. The defendant took like a single breath and then launched into, when am I going to get my phone back? This was a great day. We were doing puzzles and we were painting, and then I shoved him in a suitcase and fell asleep. 24, States versus Owen is directly on point. Florida 5th District, 2010. There, the defendant was read the 4 Miranda rights, asked if he understood them, and then asked if anyone had threatened him or promised him anything. There was no mention of any question about whether the defendant wanted to talk to law enforcement after he was given Miranda warnings. This is apparently the Federal Bureau of Investigation's Miranda warnings, which are described as exemplary. So, quoting Florida versus Powell, U.S. 2010. So, it is absolutely ridiculous hogwash that she's trying to push this through. 25, the Miranda decision never contemplated that a waiver of counsel could be accomplished by only the use of words. Quote, I am willing to answer questions without the services of a lawyer. There is no magic in these words. Any clear and unambiguous conduct by a person who has been advised on his rights, which indicates his willingness to answer questions without a lawyer, is surely sufficient. State versus Craig, Florida 1970. 26. Therefore, if the court does not strike the defendant's motion to suppress for being legally insufficient, it should deny it on its merits. If the court believed that there was a Miranda violation, then the defendant's statements are still available for use during cross-examination. fell. Only if the court finds the statements to be quote unquote involuntary will the state be prohibited from using them in cross examination. And then there was a copy sent to James Sylvan Owens. Now, there was supposed to be something else where the state sent a cease and desist or like a freaking restraining order on Sarah. Let me see if I can pull that up. Today is a not great pain day, so okay, how do I... Alrighty. You guys are listening to me tech in the background to see if I understand what I'm doing, which I don't. Okay, let me see if I can pull this up. Share this tab instead. I don't think I can embiggen this, but I will read it to you. The state requests for a protective order. You know it's bad when even the state doesn't want to deal with your ass. Okay, comes now the state of Florida by and through the undersigned assistant state attorney, and the state alleged as follows. 1. The defendant in her third amended witness list has listed the following people as witnesses. A. Custodian of Records, Orange County Office of the State Attorney. B. Domestic Violence Supervisor for the Office of the State's Attorney, 9th Judicial District, Orange County. C. Victim Advocate Supervisor for the Office of the State's Attorney, 9th Circuit, Orange County. D. Misdemeanor Supervisor for the Office of the State's Attorney, 9th Circuit, Orange County. Now, why does she want to, have all these people come in other than to say, did you know about my case? Did you watch YouTube? I mean, my guess is that the custodian of records, she is going to again complain that she never got all of her records, even though she signed off on them. The domestic violence supervisor, I'm sure she's going to try to bring in all of her cases that while it is the case that some people, a lot of women and men who are victims of DV will, maybe lose conviction to see their partner punished. And it's a terrible cycle, but I don't know for what reason she needs to see all of these people. This doesn't make any sense. 2, the state requests protective order under the Florida Rule of Criminal Procedure 3.220, subsection I, because anything these witnesses could say about the defendant and the decedent would be protected by work product privilege. Florida Rule of Criminal Procedure 3.22, subsection G, subsection L. Yes. 3, if the defendant wants public records from the state's attorney's office, she should do what everyone else has to do, and that is file a public records request. Ooh. 4, quote, subjecting prosecutors and their staff to this type of discovery of their investigation would require disclosure of work product and seriously impede criminal prosecutions. Egan versus Demanio, Florida, 1974. 5, we believe the trial court was right the first time in denying the pretrial defense efforts to subpoena 2 state attorneys and inquire into oral communications, sworn or otherwise, between them and a state witness. The oral and unrecorded statements of a witness to a state attorney are privileged as work product and not subject to discovery. Olson versus State, Florida's 5th District, 1998. See State versus Rubin, also Florida 3rd District, 1986. 6, quote, opinion work product involves a lawyer's impressions, conclusions, opinion, and theories of her client's case. Opinion work product is an absolute or nearly absolute privilege. Keating versus State, Florida 5th District, 2001. 17, fact work product concerns what the attorney did and what she learned in her role as an attorney. As the name suggests, fact work product is factual information which pertains to the client's case prepared or gathered in connection therein. This is citing Robin. 18. The fact work product is discoverable only if the parties seeking the work product show the court 1. The need for the fact worked product to prepare the party's case, and 2. That without undue hardship, the party is unable to obtain the substantial equivalent of this fact work product by other means. Thus, quote unquote need and quote unquote hardship elements must be alleged in the motion to compel an established to the court's satisfaction in adversarial hearing. 9. The state is at a loss for what non-privileged testimony any of the quote-unquote people listed above could provide the case. Well, Sarah's just not having a good day. 10. Therefore, the state is requesting the court enter a protective order to prevent any employee of the state's attorney's office from being a witness in this case. This is not going to help you. Again, the more strident, the more a-hole-ish you tend to look, the worse it is for you. Now, I believe... All right. We've got some more coming here. Just got to pull them up because I am a genius sometimes in my own mind. So then we will get to the state's preliminary objections to the defendant's amended exhibit list. So I do believe that they are trying to, the defense is trying to remove all body cam footage, all the videos of George in the suitcase. Yes, it is prejudicial, but it is also probative. I mean, it is very rare you get to see unfortunately, an unaliving happen in real time. The fact that this is damning evidence, I could see why the defense would want to keep it out, but there is no logical reason that they can. There's no legal reason that they've cited that they can't have it. Sarah signed over her phone. She said, "Here's my phone, look at it, you will find all of the evidence." Well, the fact that that didn't work out for you is not the state's fault. And generally I am on a defendant's side because the state has, the unholy power of the state. But at this point, it's one of the few times where I'm like, the state has dealt with enough BS from this woman. The state's preliminary objections to the defendant's amended exhibit list. Comes now the state of Florida by and through the undersigned state's attorney and states and alleges as follows. 1. On September 26, 2024 at 7:21 p.m., the state received an amended exhibit list from the defendant. 2. This is outside the scope of the time frame the defendant was allowed to list exhibits, but the court granted leeway for a potential extension. 3. The potential admissibility of the battered spouse evidence has changed the feasibility of all the court's deadlines in its scheduling order from August 5th, 2024. 4. Items 1 through 3, which the defendant does not even have yet, will likely require hearsay relevance and 90.403 objections to be made, resulting in their exclusion. Let me see if I can pull up what Jedi Jess is absolutely awesome, and she pulls all the things. So let me see where they got the amended. She sent me the amended motion to suppress. I think I did this one. Yeah, I don't have where this. I'm guessing that one hasn't been pulled out, so I don't know which exhibits, other than I'm guessing her exhibits are the 1 through 3 would probably be the, videos of, unfortunately, George in the suitcase, both of them, and then the interrogation. So that's what I'm guessing it was, those 3 items. Now, items 4 through 7 are police reports. Oh, I'm sorry, wait a minute. Also, these records may require the battered spouse syndrome experts to have to re-examine the defendant and potentially be redeposed. Number 5, items 4 through 7 are police reports. Police reports are inadmissible hearsay in Florida. Burgess versus State, Florida 2002. It is unclear whether the defendant believes she can use these reports in her case in chief or for potential rebuttal. I'm guessing these are the reports of the documented, mutual combat, mutual laying of hands on each other against her and George. The latter may provide some limited admissibility. Reliance on inadmissible evidence by experts is permissible, but does not make the inadmissible evidence admissible. King Bob, I am having a really fuzzy moment. I know it starts very soon, but let me check this out because my brain is only semi-functioning today. Winter is coming, y'all. Winter is coming. And that means that my leg is like, no mas, we're done. Alrighty here. I know it's starting soon. I just cannot, for the life of me, remember today. October 7th. Thank you. Thank you, all you guys who are better at me at remembering stuff. I am, in fact, getting a bigger hang up calendar to really remember things because I'm tired of pretending that I can do what I used to do. I'm going to be really real with you guys. Admitting that it's harder for me to remember things. I used to be a person that could remember things, from, just like magic. And it really is a big adjustment to having to deal with having kind of this pain fog or this brain fog. It really is. But I am definitely going to be getting a calendar, a new one, a better calendar. It's going to be huge. Let's see. 6, regarding items 8 through 11, the state notifies the defendant that it will potentially use photographs of Jorge Torres's injuries as well. And I will say these injuries, if you guys haven't, and I need to get better at plugging my own videos, but I did an entire breakdown on the autopsy report, and some of the injuries are insane. He had a deep brain hemorrhage, beyond the skull. You have a sort of semi-permeable, very thick, think like thick plastic or like a tablecloth. You kind of have a thick plastic barrier underneath your skull between the brain and the bone. And there was bleeding above that and below that. That is incredibly dangerous. I don't know that whether, and this is conjecture on my point. I have never even watched a single episode of Grey's Anatomy. So, but I do know that when you have a deep brain bleed like that, it leads to swelling and pressure in the brain, which could become so severe that it basically completely cuts off your lower brain functions, your autonomic system. So you stop breathing, you stop, your heart stops. So that is really very, very odd how that happened. And the defense attorney, this was a big issue I had with him. The defense attorney in the last hearing that we all saw and went over was saying that the head wound might have happened before he got in the suitcase. You get a head wound that extensive, you are either out or you are completely out of it. So this only puts Sarah in a worse light. I can't believe he even put that out into conjecture land. But this only paints Sarah in even worse light if he is going to try to float that, George had a head wound and then she got him to play and do puzzles and get in the suitcase. Let's see. So the state will also include testimony of the deputies who observed Jorge Torres's injuries during these prior incidents. Number 7, item 12 includes inadmissible hearsay from the defendant. Sarah trying to bring something unrelated and inadmissible into trial? I have no idea. 8. Item 13 is inadmissible character evidence. Florida Statute 90.404. If the defendant does testify that she used justifiable deadly force against George Torres on the evening she killed him, she is permitted to testify to prior acts of violence committed by George Torres that she's aware of. This, however, does not allow a quote unquote rap sheet to be admitted into evidence. 9. Item 14 is another police report, which is inadmissible as explained above. Number 10. Item 15 is an inadmissible character. Does Owens have a law license? Has anyone actually looked this up? Is this man a real lawyer, or is he just punking Sarah? Because at this point, I would think that you would know what admissible evidence and inadmissible evidence is. I mean, he's only like, what, 73? Hasn't he been a lawyer for a long time in theory? Shouldn't he know these things? I mean, what shenanigans has he been allowed to get away with because other lawyers let him, or is this just him, glad handing and, going nuts? Oh, let me fix my camera for the love of all that is Cheetos. Alrighty, let's see if we fix this. I did the amazing thing of unplugging and replugging, so, there we go. Ta-da! I'm a genius. In my own mind, which counts. I'm a Mensa member in my own mind. Reindeer, that is my question. I would not want my name attached as a professional to a case that is being run and someone that's putting in motions that are so poorly constructed. I don't know. Now let's see. 10 item, okay, is inadmissible character evidence. The attacks on the decedent's character in a self-defense case are limited to reputation for violence, evidence, and specific acts of violence which the decedent committed that the defendant is aware of. Yeah, but is it good to get infamous and not famous, Lisa? That's my issue. My opinion is he's trying to get famous from this case. Instead of filing his motions by 11:59 Friday, he was on court TV. Well, of course he was. But if I'm going to get famous, I'm going to do King Bob, I am if you are trying to work the wish list that I tried to make on Amazon, I cannot help you. I don't know what I did wrong. I have no idea what I'm doing. It is just, me. So I am working on fixing that so it actually works. But I have no idea. To be very fair with you, I'm trying not to put my home address out there, but it just seems to be weird. So I just appreciate you guys watching. I know people had asked about a wish list, but you guys know how dead awful I am with technology and anything. Let's see. Number 11, item 16 is irrelevant and likely filled with hearsay. The state has not been provided with this. Oh, well then I have, yeah, the membership should go through, which reminds me, I have memberships to gift. Da-da-da. Close. I know I can do this. I think. It's always very... I love me when I'm talking me through what I'm supposed to know already how to do. Yeah, he just doesn't seem like a professional lawyer. I don't quite understand his whole personality in court, the way he presents himself, seems more like a petulant teenager than a professional lawyer. A professional lawyer would, would have researched how absolutely the F done this judge was with Sarah Boone. He would have read that 15-page, like, you FA, you FO, Sarah Boone, and would have realized that his likelihood of getting a continuance was, less than me ever appreciating daylight savings time, which I don't. I think daylight savings time was an idea hatched in the furthest depths of hell. Changed my mind. But he had no understanding of what he was walking into. He had no understanding of, the absolute doneness everyone was with Sarah. And now he is acting like, because he is a new participant in this, he should get rights and privileges. No, Jorge deserves his day in court. The family deserves it. And Sarah, for as much as I don't like her, should be getting her day in court. It's been 4 years. And even though most of the hindrance was her own making, it's just absolutely ridiculous. Now, items 12. Items 17 and 18 are irrelevant and inadmissible. 13. Item 19A through O are inadmissible hearsay. In the 911 calls the undersigned has heard from June 18th, 2019 and September 4th, 2019, the defendant makes it clear to the dispatchers that this is, quote, not an emergency, end quote. And these statements are not excited utterances. They are merely inadmissible self-serving hearsay. The remainder of the calls were not potentially relevant to this case until the defendant alleged the relevance of battered spouse syndrome evidence and have not been reviewed by the state. 14. Item 20 does not appear to be relevant other than showing that the defendant had no injuries. 15. Unless otherwise noted below, the state does not have any preliminary objections to items 21 through 51 without waiving any potential objections as the trial develops, and not waiving the predicate for photograph, video, or movie being required prior to these items being admitted into evidence. 16. Items 25 through 28 are irrelevant. I love how they're like, we're going to throw you a bone. We don't have a problem of 21 through 51. And then they're like, okay, but 25 through 28 are stupid. Items 23, 34, 35, and 38 are duplicative. 18. Item 41 is irrelevant. I am writing all these down with my new super duper Sailor Moon. It's Sailor Neptune's pointer pen, because I've always needed a pen that I could reach out and touch someone with. So let's see. These are 25, 26, 27, 28, and then you've got 23, 34, 35, and 38. You've got 41 being irrelevant. You've got 33 and 34, or 43 are duplicative. And then 20, item 48 contains inadmissible hearsay. 21, item 51 contains inadmissible hearsay. So I love that they're like, no, you did an okay job on 21 through 51, but here's all the way you screwed them up. He's not prepared because he's not focusing on the right things. It does seem like he is discombobulated in the most odd way. I am almost too type A to function, which is weird because I also have ADHD, which means I'm almost too unorganized to function too. But when I do attempt to organize, I have great to-do lists. But if I were a lawyer, okay, as a person, as a human being, one of my biggest fears is looking stupid in public. And I don't mean like, having funny hair or wearing Sailor Moon out, because those are awesome things. I am talking about looking undeniably like dumb in public. So when I know I have something to do and I have to go out in public and function, I almost over prepare because I never want to look like a dumbass in front of you people or in front of people. I mean, I I'm generally a mostly unserious person, but I put a lot of work into my channel because I like being organized to a point. I used to be much more organized. I mean, you've never seen it, but I was. I promise, Scout's honor ish. Look, I've always been a hot mess express, but my struggle bus does sometimes go on easy mode. Anywho, what in the hell is this lawyer's problem? I would think looking like an a-hole in front of the entire court where I still practice in theory to be a lawyer would be kind of, upsetting. Uh, so this is all now I Jedi Jess is really good at getting me all of the sort of information and latest hearing or latest you know motions, but I don't think we got what the state decided or what the defense decided that they were going to drop as their exhibit. Okay. Oh, here we go. I found it. So this is the state's second amended, and then we've got okay. So we've got what is current. I will say that you guys, I don't see this going the way that Sarah thinks it's going to go. Not that, oh, and thank you, King Bob, for gifting a membership. And that went to King Bob. You are your own hero. And I have been questioning since day one this attorney's, I guess, motivation for becoming Sarah Boone's lawyer at this late date. I feel like the case is somewhat a slam dunk, and I don't mean that in like she shouldn't get due process or anything like that. But we've all seen the video, and now it's a question of holding the state to its burden. And unfortunately, some cases are like that. Some cases are, your client did a bad thing. And if you are new to the channel, then I do little tags a la Baker. Baker does Post-its. He let me kind of make these my own thing. And let me see if I can embiggen me. So in the background, beyond all the chaos of my display case right now, there is a little wooden thing right behind me that I put all the tags from this year. So I just put in when you guys send a super chat or you hide, or not hide, you gift a membership or you become a membership, or a member, I make a tag and just put it in there. And honest to goodness, this channel has been amazing for me. I don't know how many of you are new here, but it has not been an easy thing adjusting to my diagnosis of complex regional pain syndrome and all of the limitations that has really put. And Derek Rossborough, you were given a membership, so welcome to the Church of Mo again. But it was an incredibly lonely time, and I will honestly and forever say that getting this channel going and meeting all of you lovely people and the support that I've received really changed a lot of the things that I was going through. It didn't make it any easier. It doesn't mean that I don't have, bad pain days or anything like that. It simply means that I now have a tribe. I now have people that understand what this is like. And I've gotten so much wisdom, so much, understanding, and so much just encouragement from everyone. So I love having something that kind of commemorates that and really, shows that I appreciate you guys. Apparently, there was another state objection to a second amended reciprocal discovery exhibit list, and this includes receiving the amended exhibit list at 10:44 p.m. on September 26th. The only apparent change was adding item 13, jailhouse phone calls involving the defendant and third parties when received. The state may introduce statements from the defendant as a party opponent. The state is struggling to see any hearsay exceptions, which will allow the defendant to introduce any jail phone calls. So I don't know what the point is with having these jail phone calls. I understand. Let's get real here, you guys. Sarah Boone is no one's idea of a sympathetic character. She is, I think, wildly overestimating her ability to seem sympathetic and relatable as she is using this battered spouse syndrome. And I don't know, again, I really am waiting for the hearing where the defense is going to explain how you self-defense, uh, you know, self-defense suitcase someone. Oh, goodness, Derek, no, you are fine. Look, I have 6 kiddos. I have 6 kiddos, and I see grocery prices everywhere. I understand that, some months might not be possible to subscribe, and that is totally okay. I enjoy having you guys hang out, and Mr. Mo enjoys that I found a tribe that he no longer has to listen to my weird court stuff because he's like, "You really like this?" And I'm like, yeah, I love this. This is so interesting. So I will say that. And then I do have I will be putting a poll up. I am working my darndest to get my Sailor Moon cross stitch done. And I think I will be able to. Let's see if we can get this up and going. I am working my darndest to get my Sailor Moon cross stitch done before Sarah Boone starts because I love a wheelie chair. Pay no attention to the nearly mobile and very, very klutzy person on the screen. I got this really cool overhead doodad to hook my new camera onto when I can that will zoom, so I won't have to adjust the camera as much in theory, which would be great because y'all know how absolutely technologically genius I am. But we will share this. So I am nearly done with this particular project. I've got maybe 3 or 4 more days to go, but it is Sailor Moon. Eventually it is going to look like this. Let me see if I can get it closer to the camera. Oh, it is coming in upside down. So eventually it will look like this. And then we have a choice for Sarah Boone. I will be putting up a poll with pictures. I just now came to realize that there is a thing called diamond painting. I know, me not knowing that there was a thing that combined bedazzling and arts and crafts. Who knew? So I do have 2 different diamond art kits that I bought, and of course my husband caught me because they were sent in a huge package, and I'm not supposed to be buying any more craft stuff. Don't tell him though, because I already have like a couple of Sailor Moon cross stitches that are new, that are in my to buy when feeling sad thing. Oh, and did I get all of the accessories? Yes, I got a light board and everything because if I am going all in on bedazzling, we are going all in. I even got a little pen. This is the coolest thing ever. I'm geeking out for no reason, but it's got a little light on it. I have my own little crafting lightsaber that I'll probably bedazzle too. Let's be real. Anywho, I will be putting up the Sarah Boone project for Quartz and Crafts. That is kind of, I'll be moving it to quartz and crafts since quartz and cross stitch, might not be applicable depending on what you guys choose for the next craft project to be. But that is all that I have for today, and I figured I'd give you guys kind of an update. I am going to go sit down and call an insurance agent, our insurance agent, for middle daughter to make sure that we've got her quote right and that they have that she's a good student. And in case you missed it today, as I mentioned, I have 6 children. Yes, I did find a new hobby. It's called cross stitch. We're good. We have both been Bob Barkered, spayed and neutered. We don't have to worry about any more puppies. At least I hope. Thank you, Wolfram, for gifting 5 memberships, and those went to Kova42, Janine J, Graceful Klutz, Jill Sturgis, and Restium. I actually got that right. I was very proud of myself. I butcher names with alacrity, so I am proud of me. So I will write these down and put these up. Oh, wow. I'll have to look. That's awesome. So thank you guys for becoming members of the Church of Mo. We have dark chocolate sarcasm. I do ask that you destroy all plastic recorders. Those things are audio assault weapons. I have been forced many, many times to listen to recitals of hot cross buns. And I'm telling you, the therapy I need, it's just not worth it. If I were president, it would be one of my few executive orders. I would banish and get rid of all recorders. Those plastic flutes are parental terrorism, and you cannot change my mind. But anywho, I thought I'd give you guys, if you were here with Mornings with Mo, you've heard this story. But my youngest, most ferals tend to make me question whether I'm doing anything parenting right. But as I was driving, you can, to the email I have on my page, but I still have a Yahoo, so you guys can make fun of me, but I will not, I'm just not going to get another email. Look, I already forget my password to everything. I just won't. Look, I'm not adding another thing that I don't remember. But as I am driving the youngest to most feral, my 9-year-old who is, I swear to God, I birthed Bobby Hill. Bobby Hill and Chris Farley. That is who I birthed. So I have my 9-year-old and then my youngest, most feral Griffin in the back. And I guess they had one of those, dangerous people in school drills. And I wasn't really listening. I was paying attention, but I was kind of just driving. And my son was like, "Oh, no, mom would run in and take care of us." And I was like, "What do you mean?" And they're like, "Yeah, mom, you'd come in and tell him that you need to talk to his manager." And I was like, "What?" I mean, I love you boys that you know that I would go full on honey badger for you, but why would I just, find the bad guy and ask to speak to his manager? And they were like, "Well, have you seen you when you yell? You're really scary." I was like, "Well, true, but okay." Again, why would I speak to his manager? So they came up with the idea because I have just now broken down and gotten a walker, which I will be bedazzling. Let's be real here. We will bedazzle this. And my youngest, Griffin, said, "Yeah, but that roller thing you have doesn't have any weapons, does it?" And I was like, "Well, no, not right now, but I could make it a tacti-walker." So I love that my boys do know that, I would become an absolute honey badger should anyone try to mess with them. I'm kind of wish that my superpower wasn't like asking for the manager because I've never really been a Karen to anyone. But they're like, "You can yell really loud and you're kind of scary and you like to use curse words." And I was like, "Those all resemble me, yes." But then they're like, "Yeah, if you attached some weapons to your roller thing, you could be really, really awesome. You'd be like Terminator, but not." So, I may or may not be figuring out how to make a tactical walker. I'm just saying, because that's a great idea. Can you imagine the marketability in these uncertain times? When you need, stability in both your mobility and your tactability, the Tactawalker. Oh, Lord. I love my kiddos, but sometimes I swear, I'm like, "Where do you come up with these things? I love you guys, but, it is what it is." I will take care of them regard to the ends of the earth, even if that means calling someone's manager. Well, you guys, I am going to go see, if the I bought this stuff that's supposed to take care of that grody stuff that grows on the inside of that seal thing for front loading wash machines. Note to chat, if I ever decide, should we buy a new wash machine? And I say, a front loader wouldn't be too bad. Tell me no. No, these are just mold machines. Change my mind. They are. When you have a large family and you can never leave the, door open, they are just mold machines. So I got stuff that's supposed to clear that out, and I'm gonna go check on it because it's supposed to harden for hours. I don't know. Please, Lord, don't let me ruin the wash machine because we have too many people in this house and not enough towels. On that note, I will let you guys go. Let me see who is, streaming right now so I can, send you over to someone that is going on right now. Doo-doo-doo. All right, so it looks like we have a recovery addict, we have Nick, doing the young thug, and then we have, it looks like Megan Fox and Broken Baker, or Boone's Looney Tunes with, Ada K. I think what I will do is send you guys to Megan. I am not even sure. So, oh God, it's about Maya. I'm gonna lose my ever living patooties. Y'all, I will tell you quite honestly, I have never made an angry video calling someone out before. It was my first angry rant video, but I have never been more angry, more pissed off for a child and a fellow CRPS sufferer than when they leaked Maya's homecoming dance photos to try to discredit her. Because if you deal with chronic pain, if you are a person that deals with, say, chronic migraines or things like that, even depressions, we shouldn't be asking a child who lost their mother to be performatively in pain every day. Because I will tell you, as a CRPS person, we're in pain every damn day. We put a smile on, we work, we try to do as much as we can, but she shouldn't have had to forego homecoming in order to, make the hospital believe her. She was diagnosed several times and she was coded and billed for CRPS. It is just beyond me. And this is why I will never respect Coffin Dinger. I call her Coffin Digger. I know that's not good and it's petty, but look, in the defense of others and a child, I will go full honey badger mode. And I have no respect for a grown ass woman who trolls a kid's not YouTube, Snapchat account to find pictures to discredit her when she's lost her mother. And she's already dealing with more pain and has more brass boobs than that coffin chick ever did. So, now that I'm all irritated again, I'm probably gonna go watch Megan with you guys. I will see you guys later. Sorry for getting ranty, but I have never been so irritated in my entire life over that case, and I couldn't even watch it because it was too hard for me to watch. A bunch of medical people have no regard for someone who's going through with grace, might I add, because I did not. I had a 2-year pity party and just barely got out of it. Uh, a child who dealt with all this and the loss of her mother, the loss of her entire family for months in a cold, unloving hospital where they were testing the reality of her CRPS. It is beyond disgusting what they did to her, and I might have a ranty video if we're gonna get back on this, y'all. I will see you guys. Be kind to yourself, be kind to others, and for my only advice is as an introvert, if you struggle with reaching out to other people, try just giving compliments. That is what I try to do every day, 5 times if I'm out, find someone, say, "I like your t-shirt, I like your shoes, that looks like a fun cart," I'm trying to be a little bit more people-y, even though I'm happiest in my room, to be honest. Bye, you guys. Have a great day. I will see you tonight at 7 p.m. for Nightly Newsy News, where we will be going through more of what in the timeline am I here for. And if you think about it, keep the service members in your thoughts and prayers. Things are kicking off in the Middle East. I know I don't tend to cover it because that's not the kind of channel I am, but it is worrying for those of us who have family members that are service members. We know what it means when things kick off, and it's not great for those of us, the family members that go to defend our freedom, and we stay home and we try to be supportive, but it's scary out there. Bye, guys.